This is The Briefing, a podcast presented by Mussio Goodman Law Firm.
Today the topic is removing an executor, and we're here with Wes Mussio, the managing partner from Mussio Goodman.
Thank you.
I don't trust the executor and want to remove her as the executor. How do I do that?
Well, the way an executor is appointed, it has to be through the court system called a grant of probate or letters of administration. So it's actually a court-appointed person, the executor. And so what you have to do is you have to bring your own court application to remove the individual if you have grounds to do so. So it actually involves a formal process of going to court to remove the executor. You can't just walk over and say to the person, hey, you should no longer be the executor, goodbye. That doesn't work. It actually has to be by the court.
Is it easy to get rid of the executor I don't like or trust?
The answer is it can be, depending on the situation, but usually it's difficult because the underlying principle is that the courts say, well, listen, the testator or the will maker chose this individual to be the executor. They must have trusted them. So therefore, we're going to give autonomy to the testator on what his choice was. And so that's the starting principle, but there is quite a few reasons why you can definitely get rid of an executor, especially if they act inappropriately through the stages of winding down the estate.
What does the court look at to decide if the executor should be removed?
Well, there's a bunch of factors that I can use when I bring these applications. And I can tell you these applications are very, very common because the one thing I've noticed the most in the state litigation is that there's so many distrust between beneficiaries and executors, especially if it's a brother-sister or brother-brother, sister-sister situation. So there's quite a few ways to look at that. One of which, and the easy one, is whether or not the executor is using the assets of the estate to their own benefit. Let's give you a simple example. This happens quite often is the executor moves into the house of the parent and says, yeah, I'm going to be selling it, but never does and doesn't pay rent, just stays in that house rent-free. So that would be an example where you can come in and try to remove the executor. Or if they're in a conflict of interest. Another example, if the testator gave a loan to the executor for $100,000, and then when the executor's winding up the estate, forgets about putting that money back into the estate, and so that would be a conflict of interest. Another example would be where the executor is refusing to cooperate with the beneficiaries by giving them simple information like, here's the accounting, here's what the assets are, here's what the liabilities are, here's the background to that. And they refuse to do that, or they get to be very confrontational or adversarial towards a beneficiary. So sending, ridiculous emails or phone calls yelling at the beneficiary or just being antagonistic, and obviously not a person that looks neutral, fair, and reasonable. Because the court wants the executor who's appointed by the court to be fair, reasonable, and equitable, and make sure that they're providing ultimately for the beneficiary, because the ultimate hope is that the estate is wound up as quickly as possible and the maximum benefit to the beneficiaries. So if the executor is not doing that, then there's a sound ground for getting rid of them. And on that point, the final big one would be is if the executor is just doing nothing, not winding up the estate fast enough. There's plenty of case law to say that they should be removed and put somebody in there that actually wants to get the estate wound up and paid out to the beneficiaries. And if you have any further questions on this topic or others, feel free to reach out to me at my email, mussio@mussiogoodman.com, or give me a call at 604-336-8002.